We find no infirmity in the order passed by the learned single judge, and hence the writ appeal fails, and the same is dismissed as being devoid of merits. It shall thus be appropriate for the respondents to give preference to the appellant while making any fresh selection or appointment for the post of daily wager or work charge employee or master role in future vacancies.
Obliged, my lords. Do it later. If more does we expected from the of the respondents of the from the recordings of the respondents.
Supplementary cause list 2, item number 22 for judgment.
So ठीक करना पड़ेगा. The appeal is allowed. The accused appellant is acquitted of the charges. He is in custody and shall be released from prison forthwith if not wanted in any other case. You have to write a pen. He shall furnish a bail bond in the event of finding an appeal of hearing. That has to be incorporated. Okay.
Deeply obliged.
I just slipped my mind actually.
Yeah, please, your lordship. Actually, I take to mention item number 15, lordship, with the consent of the other side. Actually, 1 week time may be given for filing our reply, lordship.
You are for the
Petitioner.
and counsel for the petitioner is for and is granted. Reply pleadings in appeal. Why pleadings are required?
Lordship, last occasion court has directed to file affidavit
Okay.
in the
Counsel for the respondent. Appellant prays for and is granted 3 weeks time to file reply affidavit. List after 3 weeks.
obliged.
Please, your lordship. So item number 12, your lordship. Maybe pass over for that day, your lordship.
A request is made on behalf of Mr. KL to adjourn the matter. List after 1 week.
Obliged.
May I please, Your Lordship, I beg to mention item number 14,
4-0.
1-4.
Yes.
Lordship, we have been.
1-4 has already been adjourned just now.
That was
12.
1-5 tha kya? Okay, you are for the,
Respondents.
why adjournment is required?
Lordship, we have been newly engaged. We need time to file affidavit.
Council MS so and so submits that she has been recently engaged by the respondent and needs some time to complete her instructions. List of 2 weeks.
My Lordship, I become at number 1. Lord, in this case, Lord, the respondent has filed an affidavit. I got the copy yesterday, Lord.
Hmm.
So some time may kindly.
And counsel for the, you are for the appellant, Union of India.
I am for the appellant.
Union of India submits that an affidavit has been filed on behalf of the respondents recently herein below, before, and that he needs some time to go through the same and respond if so required. List after 4 weeks as prayed.
My Lordship. Item number 1.
I am calling for listing a new matter on Monday.
What is the matter? gentlemen?
It was the for appointment of the president of a discrimination committee meeting. The honorable court was pleased to pass an interim order
Mm,
and the respondent came for vacating.
Hmm.
And the honorable court was held that since he is appointed and discharging,
mm.
but he is not discharging duties on the date of
So it is against, it is a writ appeal.
against the IA in the local application.
IA in the,
In the writ petition.
it's a pending writ petition in this
No,
court.
accordingly, writ petition also disposed of.
So then IA in which matter? In a disposed of writ petition,
Yes, in person.
All right. get it listed on Monday.
Population.
Daily list for orders, item 3.
You have not
Lordship-
taken steps.
Lordship, in fact, there has been some confusion with my clerk. Steps were previously taken in the month of May, but
Mm.
there was an order for fresh steps.
Fresh steps in terms
Yes,
of the order
yes.
dated 17/7/2023
I do. agree.
have not been taken.
Lordship,
Then Deputy SJ, Mr. Chaudhary,
By
to
Tuesday,
take
Lordship,
requisite steps within next 7 days.
Lordship,
Thereafter, notices be issued to the respondents.
I have obliged, Lordship.
Item number 4,
Sorry,
What happened?
Mala, this is a contempt petition, Mala.
By the Union of India.
By Indian Affairs, there is page number 48, Mala, can you see?
What is the direction?
Mala, clause 22, the Deputy Commissioner Kamrup Guwahati is therefore directed to comply with the direction of landed single judge dated 8/6/2023 within the time stipulated therein within 2 months, Mala.
Mhm.
The single judge order is Mala, page number 16, Mala.
Hmm.
That Railway Authority has filed a writ petition for demarcation of the railway land, Mala.
Mhm.
And another petitioner that is page number 20 is the railway case, my lord. Fact of the 183/2022 that has been filed by the Railway Authority, my lord.
Okay. Issue notice to the respondent. Heard? Issue notice to the respondent. Steps for service be taken in 7 days whereafter process be issued. The rule is made returnable on 12th October.
My lord, I have a humble player, my lord, if possible. My lord, in that in the disputed land, one flat construction of flat is going on, my lord. So, my lord,
Contempt you want
yes,
stay.
my lord.
Let the respondent come.
Yes, my lord.
item number 5,
May I please, Chief? Also, in this case, I am appearing for respondent number 6.
Mm.
Also, in this case, I was supposed to file
Objection.
Some more time may be given, Chief.
And Council MS, are they be appearing for the respondent number 6? Seeks one more opportunity to file objection in the application seeking condonation of delay in the interest of justice. 3 weeks further opportunity is granted to for doing the needful.
Obliged.
List after 3 weeks.
Item number 6.
Please, please matter make kindly pass over for the time.
Pass.
Timing,
Item number 7.
My please, your lordship. Lordship, the IA is for condonation of 59 days delay in filing the reductive lordship.
No objection.
Yes, lordship.
Anyone for response number 7 and 8? Last date, we said that standing council be informed.
But for 8, I'm appearing.
And 7,
7,
you are appearing. Any objection to the prayer for condonation? All right, delay condonation allowed. The writ appeal be numbered and will listed for admission.
Item number 8.
May I please, your lordship? Lordship, this IA has been filed in a disposed of PIL, your lordship. And the matter pertains to your lordship, non-compliance of the order passed in PIL 55.
What was the
directing your
order?
Authority to make the mental health boards functional, your lordship. Those mental health review boards were supposed to be functional from 1st of April,
Okay.
but they have not been made functional yet, your lordship. If the lordship comes to the lordship's order, dated 13/12/2022 at page 15 of the IA, your lordship.
All right, madam, you need to respond.
My lord, meetings of the mental health board are supposed to be held in the month of August and September, my lord. And district level, my lord, mental health, my lord, teams are conducting, well, in every jails, my lord.
The allegation is that the boards have not yet become functional.
Yes, my lord, it will be functional, my lord. We have received instructions, my lord, and we would like.
Direction was to do it by April.
My lord,
So whatever work has been done,
yes,
please
my lord.
place it on record in
Yes,
form
my
of
lord.
an affidavit.
We have.
Issue notice, MS. Your good name, please.
R. Barua, my lord.
R. Barua puts in appearance on behalf of the respondents.
Yes, my lord. On
All respondents,
1 to 7, my lord.
respondents numbers 1 to 7. The response number 9 and 10 are shall be intimated to appear in these proceedings. Process be issued to the respondent number 8. Respondent number 8, you would not be appearing. So government
My lord, Director,
8 also?
Mental health.
well, Director Lokopriya Gopinath.
No.
My lord, I'll take instructions
All right.
regarding
She
this.
also
this
assured
one,
that
my lord.
she would be taking instructions on behalf of the respondent number 8. Affidavit on behalf of the respondents be furnished regarding the amendments made in this application be filed within next 4 weeks. List after 4 weeks.
Deeply obliged.
Much obliged.
Item number 9.
My lord, this matter relates to pay parity. Now, of the, my lord, Ayurvedic doctors vis-a-vis the allopathic.
Is
doctors.
there a Supreme Court judgment, recent Supreme Court?
Yes. Following that, my lord,
Hmm.
the order has been passed. Our petition has been dismissed.
Hmm.
But prior to that, my lord, there are 2 other Supreme Court judgments.
Hmm.
And the order which was relied upon by the learned single judge, that is also being reviewed now, my lord. That is under review. Because of the, yes, my lord.
Let's-
Yes, compilation.
So then wait for the review to be decided.
In the meantime, lordship will issue notice in both the matters, my lord.
Which is the order
Yes,
which was relied upon?
The order which was relied upon is at page 31, my lord.
State of Gujarat PA part.
Yes. Now at page 36, my lord, 2 issues were framed at para 24, page 36.
Yes.
Whether different scales of pay can be fixed for officers appointed to the same cadre on the basis of educational qualification possessed by them. Whether allopathy doctors and doctors of indigenous medicines can be said to be performing equal so as to be entitled to equal pay. My lord, the first issue may not be, but second issue, which has been
Para
answered. my lord.
38
Yes,
onwards.
yes. Second issue has been answered at page number, my lord. Um, Page 45, my lord. Therefore, even while para 54, even while recognizing the importance of Ayurvedic doctors and need to promote alternative indigenous system of medicine,
All right.
we
So
cannot.
this was issued, this issue was decided against the doctors.
Yes, my lord.
Now, where is the review?
Yes, review order, my lord, is at page 46.
Hmm.
The matter was actually.
Modification, they have sought modification. Not,
These are interconnected, my lord. There is one writ petition and one review petition, my lord. Kindly see at page 47. These are interconnected matters.
what has
One
been
writ
done, whether
petition
the reviews
filed-
have been entertained or it's just,
No, my lord, because because Honorable Justice,
the simply order is to place
no,
before
my
Honorable
lord,
the
in
Chief
fact,
Justice.
the bench which the judgment passed the earlier order, one of the.
One of the honorable
judge
judges
retired.
is superannuated,
Retired.
yes.
Since
So-
the other judge was there, my lord, therefore court felt that it should be placed before the
All right,
appropriate.
then, Ms. Saikia, we'll wait.
Yes, Lord.
Otherwise, the issue is decided against them.
Yes. No,
Uh,
not decided that way, my lord. In fact, my lord, this is kindly come to my lord for judgment. Please come to page 1 to 6, my lord.
1 to 6.
Page 1, page 1 of the compilation, my lord.
The earlier judgment,
Yes,
was it, what does it say?
yes, my lord. It will and the see.
There is a age now, I think
No, no,
there's
my
a
lord.
recent
No, other matters are also there, my.
age, there is a recent judgment, I think,
No, my
later
lord.
judgment of the
No,
Supreme
my lord,
Court.
I'll place, my lord. Please, sorry, take the memo of appeal, my lord.
Mr. Chaudhary, I have a faint recollection that just the last month,
No,
there was one judgment regarding
After PA, but there is no other judgment.
age.
Age.
On age aspect, there is a
Age
judgment.
issue has been decided, my lord, in
Against-
favor of the all doctors, Ayurvedic doctors. My lord,
There's
Ram Naresh,
one judgment, probably dental.
recently, Uttarakhand High Court passed an order on pay parity. SLP file, SLP dismissed. Telangana High Court Division Bench decided the issue in favor of Ayurvedic doctors. SLP file, SLP dismissed. And my lord, in that the Ram Naresh case, Honorable Supreme Court says, merely because, my lord, I mean, the different procedures are adopted for the purpose
Not
of treatment.
procedure, the entire educational criterion is totally different. Mr.
No, my lord, no,
Yeah.
Supreme Court.
Admission, this, that, everything is different.
Kindly have the judgment for a moment, my lord.
Anyhow,
At this stage.
issue notice. And Advocate General Ms. Saikia puts in appearance on behalf of all respondents,
All state respondents.
all respondents' numbers. One, two, 1 and 2,
One
there
and
are
two,
only
Lordship.
2 respondents. Copy of the writ appeal be provided to Ms. Saikia.
Item number 10 regarding age, my lord. Same.
List for admission after 6 weeks.
Both the matters, 9 and 10.
Highly obliged.
My lord, the compilation I can give at the time of
Later.
hearing again. That will be better. Otherwise, my lord, give me this.
Take down. Mr. Senior Counsel, Mr. K. N. Chaudhary, representing the appellants, urges that the judgment rendered by Honorable the Supreme Court in the case of State of Gujarat versus Dr. P. A. Bhatt and others reported in 2023 SCC Online 503, based whereupon, the writ petition was dismissed, has been has been made subject, a review petition has been filed
Yes.
in the said matter, and thus, it would be opposite to consider these writ appeals on merits after the fate of the aforesaid review petition. Number house. Issue notice, list after 6 weeks.
Deep level.
Highly obliged.
Signal level, huh?
Item number 11.
May please, your lordship.
Yes, please.
My lord, here in this case, my lord, the petitioner has challenged the, my lord, e-auction notice as well as, my lord, the sale order notice, my lord. My lord, in issuing this e-auction notice, only 15 days time is given, but the provision says that should be 30 days. And, my lord, the auction, my lord, sale notice, when mother is offering that, approaching the bank that I am clearing the amount, and he also deposited some amount, 50%, and pays for some more time to pay the rest amount.
Go to the
The-
DRT or DRAT, wherever the proceedings are. Why red court should entertain red petition? This is statutory remedies available.
My lord,
Then
they have approached the tribunal. Tribunal, they have approached and we have appeared. And when the matter is sub judice before the tribunal, they have issued the options, my lord, sale notice, my lord. That is also, my lord, the violation of section 19 of the act, my lord.
let us see where are the proceedings.
My lord.
Securitization Act.
Yes, my lord, the e-auction notice you will find, lords, you will find at page 48,
48.
my lord.
So go to the tribunal and say that they have issued the e-auction notice, even though the proceedings are pending. The tribunal will stay the notice. Why do you approach the red court then?
My lord, because they are going to sell the.
Where are the
land.
proceedings before the DRT?
Yes, my lord.
Let us know.
My lord, I have annexed the, my lord. Lordship will find, my lord, at page 55, the notice issued by this order dated 19/6/2023. I appeared, and the notice also annexer 6 also, my lord.
So all right, move an application to the DRT that
My lord,
while proceedings are pending,
my lord,
how can they issue?
I appeared. I
Yes.
appeared. But in the meantime, I am agreed by this sale notice, my lord, annexer
We are
7.
saying, Mr. Sikdar, why don't you go to the DRT and
Yes,
apprise the DRT of this
yes,
fact?
I will apprise, my lord, but we are apprehending the date is fixed to sell, my lord, and indeed that date is. My
What is the next date in the DRT?
next date, my lord?
410.
14?
410.
410, my lord.
410.
My lord. Till then, I
Mr.
will be
Ganguly.
protected, my lord.
Insofar as the original application is concerned, my lord, the DRT will not enter into the issue of the surface side notice. My lord. These are parallel jurisdictions. My lord. Both of them, my lord, doctrine of election does not apply. Transport judgment of the Supreme Court is there, my lord. It is till this day that the bank can pursue both. If he wants to challenge, my lord, he has the liberty to file an application under section 17 of the Surface Act, which the DRT will decide in accordance with law. Not in this OA, my lord, but he has to separately approach.
Move
Will
the
approach,
DRT.
my lord, on-
So do that. Who stops you? But why it is to be entertained, tell us.
My
You
lord.
have a remedy. Read section 17.
My lord, we will approach the tribunal, well, till then we may be some.
No, no question. Now Supreme Court is very emphatic on this. You dismiss a petition and still grant relief to the litigant. That's not done, sir. Absolutely. We may observe that you may approach the DRT by suitable application and the DRT will consider it as per law.
My
That's
lord,
all.
This,
Nothing beyond that.
the everything, my lord, the sale notice and the e-auction notice.
So
all
why you
filed
advise your client to approach the court? You should have asked your client to go to the DRT by way of an application under section 17. You don't dispute that the remedy is available. Is it right?
My-
Remedy is available.
available.
So go to the DRT.
My lord, we may be given liberty to approach the.
All right. This writ petition is preferred by the petitioner here for assailing the sale notice dated, which is the sale notice.
My lord, at page 57, my lord. My lord, sale e-auction sale notice, my lord, at page
E-auction sale
48.
notice
Page 48.
dated so and so, whereby, comma, the secured assets are proposed to be auctioned. Full stop. Then counsel for the petitioner is not in a position to dispute the fact that the remedy of approaching the DRT by way of an application under section 17 of the Securitization Act 2002 is available to the petitioner for assailing such notice. He thus prays that the petitioner may be allowed to approach the DRT for ventilating the grievances against the e-auction notice. And Counsel Mr. Ganguly, representing the bank, does not object to this submission. Hence, the writ petition is disposed of as withdrawn, leaving the petitioner at liberty to avail of the appropriate legal remedy for ventilating his grievances. Legal statutory remedy. Appropriate statutory remedy. The writ petition is disposed of in these terms. Deeply obliged.
Item number 13.
What is it, madam?
Matter is relating to ration card, which is one nation, one card.
Ration card. One nation, one card. Okay.
Relating to read April 44 of 2023.
Is same one. Where there is one matter listed in the hearing category also. Call Mr. Shah, pass over. Or Shah.
Item number 16.
Also, in this matter, Lordship, we have received an affidavit by respondent number 4 yesterday, Lordship, and by respondent number 2 and 3 this morning, Lordship. We'll be requiring 3 weeks time to file a rejoinder.
Affidavits on behalf of the respondents number 2, 3, and 4 have been filed recently herein before, and counsel for the petitioner. Praise for and is granted. 4 weeks time to file affidavit in reply if so required.
Noted.
List of 4 weeks.
Item number 17.
My lord, in this matter, last evening I have been engaged on behalf of respondent number 7. Some accommodation for this day.
All right. And senior counsel, Mr. has been appears on behalf of the respondent number
7.
7. He urges that he has been engaged recently herein before and needs some time to prepare and argue the matter. The counsel for the petitioner does not object to the prayer so made. List in the second week of November.
Item number 18.
Made with your lordship. My lord, in this matter, today I am going to file an affidavit, my lord.
What is the PIL about?
My lord, it is about the state of affairs in the State Consumer Commission, my lord, the lack
Oh.
of funds and all, my lord. On the last day, lordship was pleased to direct the respondents to proceed with the appointment of
Selections.
my lord.
What has
Regular
happened?
Lordship, the process is going on, my lord.
All right, and counsel MS appearing for the respondents. Praise for and is granted. Further opportunity of 2 weeks to file affidavit in terms of the order related to
Deeply obliged, my lord.
Deeply obliged.
list of weeks.
Obliged.
Supplementary cause list, item 20.
Made with your lordship. My lord, the issue which arose for consideration before the learned single judge was, my lord, under the scheme of the Assam Cooperative Societies Act 2007, whether there is a requirement of quorum in respect of an adjourned meeting.
Quorum.
Yes.
Okay.
Normally, my lord, in case of an, adjourned meeting, my lord, quorum is not required. That is the provision in the, that central act also and in our act also. But my lord, because my lord, in this subsection 2, in subsection 3, my lord, a word subsequent does use
Meeting
that-
convened for what purpose?
for AGM, my lord.
AGM.
Annual general meeting. Now, if your lordship will kindly come to the provision, my lord, that we have annexed. We have given the extract of the act at page 31. My lord will kindly come to page 35,
Yes.
section 34. Quorum of meeting of General Assembly.
Hmm.
The quorum for a meeting for a General Assembly shall be specified in the bylaw, but shall not be less than 10% of the members eligible to vote at the meeting. If within 1 hour from the time fixed for meeting of the General Assembly, a quorum is not present, the meeting shall stand adjourned ordinarily to the same day in the next week at the same time and place. The chairman of the meeting may, however, decide to adjourn the meeting to a later date, not later than 15 days, or as the case may be, as specified in bylaw of the society. Provided that a meeting of the special General Assembly called on the requisition of members under subsection 1 of section 33 shall not be adjourned but dissolved. So in case of a my lord requisition meeting, the position is otherwise. 3, if at any time in a meeting there is no quorum, the presiding authority shall adjourn it to such time or date as it thinks fit, and announce the same at once, and business set down for the meeting shall be brought forward at the subsequent meeting, whether at such a meeting there is quorum or not. Now, what the learned single judge, my lord, felt.
Can you narrate the factual
Yes.
background?
Factual background is, my lord, the annual general meeting of this society, of this cooperative bank, my lord, it was notified on 11/9/2020 during COVID time, my lord. Now, on the date fixed, there was no quorum. Only 28 members were present, as against the requirement of 400 and odd. So meeting was adjourned to 18. In the adjourned meeting, there were more than 100 members, my lord. And the resolutions were passed, including, my lord, agenda was passed, including, my lord, election of the board of directors. Thereafter, there is a requirement of approval of the proceedings by the Assistant Registrar of Cooperative Societies. That was also done, my lord. Now, that came to be challenged before the learned single judge. Now, on that, learned single judge has taken the view that in respect of a situation covered by subsection 2, there will be a requirement of a quorum, but in respect of a situation visualized by subsection 3, there is no requirement of quorum. But end of the day, my lord, both are adjourned meeting. One, at the beginning, there is no quorum.
Law makes a distinction. What can be done?
No,
Just read the law, plain and simple.
Yes.
Does it bring out a distinction or not in the two situations?
No, my lord, lordship will have to read the scheme of the act as a whole.
You please proceed.
Now, end of the day, my lord, be it a meeting visualized by situation under subsection 2.
Probably the intention of clause 3 is that AGM cannot be adjourned indefinitely on account of want of quorum. That is what the intention is.
Yes.
So in the second meeting, irrespective of fact, quorum was there or not, the business was conducted.
No, my lord, if that meaning is given, then, my lord, there can be a scope of mischief also. Supposing a section of the shareholders do not want that this board of directors should survive. In that case, they somehow manage that the meeting is not convened.
No, the meeting was convened.
The meeting was convened.
Then?
No, question is, my lord, under the scheme of the act, whether it is possible to carve out a distinction between a situation visualized by subsection 2 and subsection 3. Because both are adjourned. But learned single judge has taken a view that what is visualized by subsection 2 is an adjourned meeting, and what is visualized by subsection 3 is an subsequent meeting. That is the view learned single judge has taken. Whether that is correct, my lord. My humble submission is, my lord, both are in continuation of the original meeting. There cannot be any change of agenda. So in that situation, my lord will kindly see under this old act, before this.
How long, as per you, how long will the meetings be continued to be adjourned if the quorum is not present?
Precisely.
How long? On how many occasions?
Only once, my lord.
That is what has happened. Again, please narrate the sequence of events.
Yes.
Meeting was fixed on
11/9.
11/9. Quorum was not
No
available
quorum.
because of COVID. Then?
No, because of no quorum.
No quorum, all right. Then?
Then it was fixed on 18.
18th. On that day?
On that day, though the agenda was passed.
Agenda, and you are aggrieved?
I am
By-
not aggrieved.
Then
Other side, some shareholders filed the case, my lord.
they say that quorum ought to have been completed.
Yes,
Okay. Mhm.
we were the board of directors. I represent the board of directors.
Okay, okay.
Yes. Now, my lord, under the, prior to my lord enactment of the 2007 Act, my lord.
What the view has been taken presumably
Ah.
that subclause 1
Ah.
overrides subclause 2 and 3.
Yes.
Mhm.
Now, my lord will kindly come to. It's a purely a question of law, my lord. Therefore, if a lordship. will
We'll
kindly
admit the appeal then.
Huh?
We'll admit the appeal.
No, my lord, only thing is, my lord, if by 30th of September, the meeting is not held, then the board of directors will, my lord, lose their tenure in terms of section 39. So lordship will give us some protection on that, my lord. Otherwise, my lord, now today was the date fixed. But because of the learned single judge judgment, we have advised you don't do anything now. Now, if by 30th we do not hold the meeting, my lord, then we will cease to be a board of directors. Now, apparently, my lord, there is a judgment of this honorable court division bench under the old act. Well, earlier it was in the rules, rule 24, 2 and 3. Now it is section 34. Now, under the old act, there is a
Let
judgment.
us see what single judge has interpreted.
Yes, yes.
How does the
Yes,
judgment
yes.
deal with clause 3?
My lord will kindly come to page 144.
Paragraph?
1 second. Yes. Page 144, para 23. In the backdrop of the above scheme envisaged under section 34(3) of the Act, it can also be seen that the words and the business set down for meeting shall be brought forward at the subsequent meeting, whether at such meeting there is quorum or not, has to be interpreted to mean that in the subsequent meeting upon compliance of the first part of section 34(3) and section 34(5), there is no requirement of quorum. Legislative intent is clear to give an additional opportunity to the shareholders of the cooperative society to remain present in the subsequent meeting. However, if the shareholders of the cooperative society fail to remain present, legislative intent is also clear that the subsequent meeting can proceed irrespective of there being a quorum or not. At the cost of repetition, it is clarified that legislature had clearly demarcated the status of a meeting adjourned due to no initial quorum and a meeting adjourned after initial quorum. In a meeting adjourned due to initial quorum, there has to be compliance of 34(1), whereas in the subsequent meeting, there is no necessity for a quorum in terms with section 34(1) of the Act, provided the first part of section 34(3) and 34(5) of the Act is complied with. In other words, my lord, the learned, actually what had happened, my lord, prior to this judgment, the learned single judge has already rendered a judgment, my lord, where this view was taken. That judgment we have annexed, my lord. That is WPC number 3041 of 21, where it was decided on 15/11/22. If your lordship would kindly come to page 119. Para 25.
Page?
Page 119, my lord. This was the first judgment where the learned single judge took this particular view. Therefore, from the above analysis, it would be clear that in an adjourned meeting, that is meeting adjourned under 33(4) and 34(2) of the cooperative society case, there is a requirement of having a quorum of 10% of the members eligible to vote in the meeting or any
So
other
this was a
quorum.
view already taken.
Yes. This is the view, my lord. Now, my lord, division bench of this honorable court under the old rules has taken a view. I'll just place that, my lord.
Whether that judgment was brought to the notice?
No, yes, this time we brought, but in the earlier it was not.
Okay.
Yes. That judgment, my lord, is
Page 122.
122. My lord will kindly come to page 125. Para 8 on the top. Examining the facts in the light of the provisions of Rule 24, earlier it was Rule 24, now it is Section 34. It is clear that the AGM was convened on 2017-92 and only 23 shareholders turned up, but the business could not be transacted for want of quorum. The meeting was adjourned till 6/11/92. On 6/11/92, adjourned meeting was held and the election was held. Adjourned meeting is continuation of the meeting held earlier. It is stated that page 41 of the cycleton that on the law practice of meeting, sixth edition, that an adjournment, if bona fide, is only continuation of a meeting and notice that was given for the first meeting holds good for and includes all other meetings following upon it. If, however, the meeting is adjourned sine die or a fresh notice must be given, it is also stated at page 66 of the said book that an adjourned meeting is deemed to be continuation of the former meeting and no new notice is necessary unless regulations of prescribe or adjournment has since been sine die. Learned Council has also drawn our attention to the decision of the Honorable Supreme Court in case of so-and-so, where reference is made to the above passage in the law and practice of meeting. The adjourned meeting is in the eye of law continuation of the former meeting. The meeting held on 6/12/92 was continuation of the meeting held on 27/10/92. The Administrative Council of the Society could hold the AGM on or before 31/10/92. The same stood adjourned for want of quorum, and the adjourned meeting took place after a few days. The Administrative Council of the Society has aided by the requirement of section 32(2) of the Act. That being so, the view taken by the registrar.
There is a discussion that even in the adjourned meeting,
No, my lord,
the
that was
quorum
not
need
there.
not be there.
No, my lord, this is an authority for the proposition. Adjourned meeting is an
It is a continuation of the original meeting. That's a different thing. But here in the issue
No,
is,
that point is not
so
decided.
then this division bench judgment doesn't at all touch the controversy at hand.
No, my lord, my humble submission is under this, if a lordship would kindly permit me to place the provision of the, my lord, this multi-purpose cooperative societies act, my lord, at page 162, Central Act, my lord. Please come to that 31 subsection 3. The bylaw may provide for quorum at a general meeting. In the absence of such provision in the bylaw, the quorum shall be 1/5 of the total number of members. No business can be transacted without quorum. Even if the quorum drops during the proceeding of the meeting, the remaining business cannot be done and shall be put off. A meeting without quorum shall have to be adjourned to a specified date, time, date, and place, and the business or the remaining business, as the case may be, shall be transacted at the adjourned meeting, whether there is quorum or not. So, my lord, a Central Act does not make any distinction between the two, my lord. Absence of quorum in the midst of a meeting may be brought to the notice of the president of the meeting by any member if not noticed by him or by himself. My lord, having regard to the totality of facts, my humble submission is, my lord, whether it is a situation visualized by subsection 2 or whether it is a situation visualized by subsection 3, in effect or in substance, it is an adjourned meeting, my lord. And the preponderance of, my lord, the legislations, my lord, shows that in an adjourned meeting, there is no requirement of quorum.
Just let us see the first minutes of the first meeting.
Yes, my lord.
Where is it?
Minutes of the meeting, my lord, at page number 52, my lord.
11 minutes.
48, my lord. 48. 51, page 51, my lord. Page 51. At the very outset the meeting, Bholanath Sharma, Managing Director of the bank, requested the Honorable Chairman, Pranab Goswami, to take over the chair and requested to preside over the meeting as per the prefix agenda. The MD further requested so-and-so, Departmental Observer, Government of Assam, to accept his chair in dais. Then the Honorable Chairman, addressing the observer, presented director, shareholders and staff members briefly narrated about the present crisis arising out of COVID-19 for the last 6 months across the country. He further added that present meeting cannot be continued due to lack of required quorum and shall take place on 18 September 2020, Friday at the same time and place. Sri Minal Saikia, Departmental Observer, Government of Assam, informed that as per provisions of the Assam Cooperative Societies Act, Section 34, and the Bank Bylaws, Clause 21, minimum 10% of the shareholders, that is 426, should remain present to form the quorum. At 12:30
What is the
PM,
tenure of the body?
5 years, my lord.
5 years.
5 years. Now, according.
And why do we apprehend that the term will come to an end on 30th September?
30th September, because under the Act, my lord, there is a provision. If there is no AGM within 30th September, then automatically by
So then
operation.
hold a meeting. What hold a meeting?
If lordship permits, will hold, my lord.
What do you say?
Yes.
No, in fact, my lord, the honorable single judge, my lord, has directed for holding of the election. Now, at the same time,
Parallelly, my lord, the honorable single judge, my lord, has also observed that the disqualification which is otherwise attracted, my lord, in respect of their participation, that will not, my lord, come into play. So they can participate in the election, my lord, and the departmental officer, my lord, will hold the election. Before that, my lord, may I submit, my lord, the honorable single judge is very candid while saying, my lord, that there is a distinction between subsection 2 and 3. I'll, my lord, refer to only one paragraph, then everything will become clear. If your lordship comes to 144, para 25, lordship has got it, my lord.
Yes.
Yeah, my lord, the discussion is there. In the backdrop of the above analysis and proposition of law laid down, let this court consider the submission of Mr. Ken Chaudhary, the learned senior counsel on merits. In the opinion of this court, the said submission made to the effect that meeting adjourned under sections 34.2 and 34.3 of the Act of 2007 to be given the same status is misconceived in as much as already held supra. There is no meeting of the General Assembly if within the stipulated time under 34.2 of the Act of 2007, there is no quorum. So if there is no quorum, there is no meeting. As such, the meeting would not come within the ambit of an adjourned meeting of the General Assembly or can by any standard be said to be a meeting of the General Assembly. Further to that, as of the supra, as the meeting was called by the board in terms with section 32 of the Act of 2007, the said meeting which otherwise ought to have been dissolved does not get dissolved and stand adjourned by operation of law to the same day of the next week at the same time and venue. On the other hand, the proviso to subsection 34.2 of the Act of 2007 in relation to a special general meeting held in terms of the requisition made under 31.3 and 33.2 of the Act, which gets dissolved. Therefore, a meeting adjourned due to lack of initial quorum under no circumstances can be equated to an adjourned meeting or a subsequent meeting. Now, coming to the meeting referred to in subsection 3 of section 34 of the Act of 2007 is a meeting of the General Assembly as there was initial quorum. And as such, the legislature in its wisdom had mentioned the meeting so adjourned by presiding officer as a subsequent meeting, which means a continuation of the previous meeting. Therefore, the contention of the learned senior counsel for the private respondent as observed earlier is misconceived. Now, your lordship will kindly see what essentially the honorable single judge has held. Under 34.2, my lord, there was no meeting at all because there was no quorum and the meeting was, my lord, adjourned to the next date, same day, my lord, same time. So essentially, my lord, there was no quorum. Now, if your lordship comes to 34.3, my lord, I'm reading it out, 34.3, my lord, distinction will be clear. If at a meeting, if at any time in a meeting. So therefore, essentially the meeting has started. There is no quorum, the presiding authority shall adjourn it to such time or date as it thinks fit and announce the same at once, and the business set down for the meeting shall be brought forward at the subsequent meeting, whether at such meeting there is quorum or not. So therefore, my lord, when the meeting has started and midway through, my lord, the quorum drops. Then the meeting can be adjourned.
Dropping is accounted for in different provisions. Dropping, this is not a situation of quorum dropping.
There is no quorum.
Quorum dropping.
No, my lord, I'm trying to make out because the legislature has consciously, my lord, used the expression subsequent meeting. Now, in a subsequent meeting, the business can be taken forwarded. So, in respect of subsection 2, what happens, my lord? I'm reading it out again. If within 1 hour from the time fixed for meeting of the General Assembly, a quorum is not present, the meeting shall be stand adjourned. Meeting shall stand adjourned ordinarily to the same day in the next week at the same time and place. So here, my lord, taking forward of the agenda does not arise because the meeting had not taken place, my lord, since there was no quorum within 1 hour. Now, if your lordship comes to 3, if at any time in a meeting, this shows, my lord, the meeting has commenced. Meeting will not commence, my lord, unless there is a quorum.
Yes.
So this is the interpretation of the, my lord.
So the meeting had never commenced because even in the first meeting, there was no quorum admittedly.
My lord,
there were only 22 people present.
My lord, what I'm trying to say, by using the expression subsequent meeting, the legislature has distinguished, my lord, between subsection 2 and subsection 3. Now,
we are asking you,
my lord, may I put it in this way? Now, subsection 1, my lord, has to be read to be a mandatory requirement.
Yes, that is all
because
right.
the legislature has imbibed, my lord, the principle of, my lord, members' participation and democratic control. So
Mm.
therefore, my lord, this is specified, 10% is mandatory.
Mm.
And this 10% permeates through, my lord, subsection 2 and 3.
Mm.
In, my lord, neither of the stage, this 10% can be waived, my lord. Because otherwise it will defeat, my lord, the scheme. Without members' participation, my
Mr.
lord.
Counsel,
My lord.
if that had been the intention, what is the meaning of the word? Whether at such meeting there is a quorum or not?
Yes, absolutely, my lord.
Hmm.
Because your lordship will kindly say, I'm coming to that.
Mm.
Because once, my lord, there is a meeting starts with the quorum,
Mm.
but my lord, midway through, if
Quorum
the meeting,
drops.
my lord, drops, it can
So
be.
you
my lord,
mean to say
deferred
that
subsequent- subsequent
at the
meeting.
inception, there has to be 10%.
Absolutely.
So during the course, if the quorum drops,
Absolutely.
the
Absolutely. Now, in the subsequent meeting,
Mm.
the 10% is not required. In as much as in the original meeting, that 10% has already been
so
achieved.
the transactions had already started.
Started. And that can be taken to the subsequent meeting. And therefore, my lord, the legislature has consciously used, my lord, this subsequent meeting. And your lordship, if your lordship comes to 5, my lord,
Mm.
there is another, my lord, expression subsequent meeting, 4 and 5. No business, if your lordship comes to 4, no business other than the business fixed for the original meeting, which had started, shall be transacted at such subsequent meeting. So that will be, my lord, taken to the subsequent meeting. There is another provision in respect of subsequent meeting, my lord, subsection 5.
Mm.
A notice of such adjournment posted in the notice board of the head office of the cooperative society on the day on which the meeting is adjourned shall be deemed to be sufficient notice of the next subsequent meeting. So that, my lord, notice will be sufficient, my lord, notice in respect of the subsequent notice. But if your lordship sees the first, my lord, subsection 1, no, my lord, notice is necessary because the legislature has prescribed, my lord, the time, place, and venue. If your lordship again come to 1, my lord, if within 1 hour from the time fixed for meeting of the General Assembly, a quorum is not present, the meeting shall be stand adjourned ordinarily the same day in the next week at the same place and time. So for that purpose, no notice is necessary, my lord. Notice is necessary only in respect of a subsequent meeting where the meeting has commenced. The quorum is achieved, but midway through, my lord,
The quorum
has
drops.
fallen. And that business could be, my lord, taken forwarded to the next subsequent meeting. Therefore, my lord, the honorable single judge had made a distinction between 2 and 3. Now, if your lordship, my lord, foresee, my lord, the situation, if, my lord,
Your case is that the situation at hand is covered by clause 2.
absolutely, there was
Because
no
there was no quorum, there was no
quorum at
meeting.
all. There was
So
no
the
meeting.
entire thing had to be adjourned and held afresh.
Absolutely. And if your lordship says, my lord, if the requirement of quorum is waived, then the effect, my lord, is cascading. 2, 3 members, my lord, can take any decision against, my lord, the society. That will be prejudicial and detrimental, my lord. Such an interpretation, in my humble submission, is liable to be discarded, which results in anomaly, my lord. This is my humble submission, my lord.
তোমালকে যেমন এটা ASTS এর approval টো বাদ দিলা নহয় you supported that. I'm sure. Anyway.
More understanding to follow.
No, it's okay. You're at liberty.
Only 31(3), because the meeting is and some of Yes, Mr. Chaudhary.
Yes. My lord, my learned friend had made number 1, my lord, they approved the proceedings, the state.
We are not on
And on
facts.
question of
We are
law.
not on facts.
Yes. Now, my lord will kindly come to subsection 4 of section 33. I'll have to take the kitab on you.
You have given the copy.
No, well, I think that section is not there, no?
Sir, 33 is there
Okay, I'm sorry.
at page 35.
I'm sorry.
At page 35 of your
I'm
paper.
sorry.
That is
Yes.
special general meeting.
Yes, my lord. No, kindly see, my lord. Board may call a special general meeting and shall be bound to do so within 45 days of the receipt of this.
We are not dealing with the
Now,
case.
kindly come to subsection 4. Any meeting of the General Assembly other than a special general meeting with the consent of the majority of the members present, adjourned from time to time to a later hour on the same day or to any other date as may be provided by this bylaw, But no business other than that left over at the adjourned meeting shall be transacted at the next meeting. So my argument was only the exception was sought to be carved out in respect of a subsequent. My lord, use of the word subsequent is a misnomer, my lord. There's nothing like subsequent. It is an adjourned meeting. What is the scope of, my lord, conceiving an adjournment? But subsection 4 makes very clear, my lord, that even in case of an adjourned meeting, the same agenda has to be
Mr.
carried.
Chaudhary, we have to read clauses 2 and 3 of the subclause 30, section 34
Yes.
in isolation, then only we can understand. You see,
No,
the
my lord, I think it
situation
has
which
to
is
be read
contemplated.
harmoniously, my lord. The scheme of the act, my lord, the end of the day, whether the meeting could not commence because of
Whether
lack
there
of,
was a meeting or not,
my lord.
whether there was a meeting or not, that is the question.
Now, whether in subsection 3 there was a meeting, my lord, even
Yes.
though meeting started, even in case of subsection 3 also there is no meeting. Because
Yes.
there is the end of the day, my lord.
No, no,
anytime-
there is a meeting and the members walk out.
No, my lord, kindly
Walk out.
see, the word meeting is used in subsection 2 also.
Yes. One
If-
within 1 hour.
Huh.
So that means that once the meeting commences, once the proceedings commence,
Yes.
the assembly commences, the chairperson or the secretary, as the case may be, who looks after it, they will wait for 1 hour for counting the heads. In 1 hour, the quorum is not formed, then adjourn without touching the business. Whereas the second, the clause 3 says that if any time in a meeting can only be considered when the quorum is present. Without quorum, there is no meeting.
So in
That is
either case, there is no meeting then, my lord.
No. In the first case, there was never a quorum, so there was no meeting. In the second case, it contemplates beginning of a meeting with a quorum and then dropping of the quorum in the meanwhile.
My lord, with utmost respect, I'll submit, my lord. In both the situation, there was meeting. In both the situation, my lord, there
If
was.
at any time and if within 1 hour, that makes the difference.
No, my lord. That means at the beginning.
At the beginning, there is a quorum and then it starts falling.
My lord, subsection 2 visualizes a situation where at the initiation.
At the initiation,
And in subsection 3 visualizes anytime.
anytime. Yes.
Now,
So that
my
is the
humble
change.
submission is what is the net effect, my lord? Effect is when both the cases meeting
Net effect
adjourned.
is work started and then the lawyers walked out. The court will not dismiss it for want of prosecution, or it may.
No,
That is the only thing. That is the analogy.
No. No, my lord, my humble submission is if you.
You see, the difference
look at
is, Mr. Chaudhary, the
Yes.
difference is the bar members come and request the court. Sir, this thing has happened. Kindly don't pass an adverse order. And the second situation is in the midst of the court proceedings, the bar members throw down the files and walk out. So this is the subtle difference.
No, my lord. My
Now,
humble
if you have
submission
anything,
is
any
either
different
situation-
interpretation, please let us know.
No, my lord, in either situation, with utmost respect, I'll submit, my lord.
Yes.
It is an adjourned meeting. And in the adjourned meeting, what can be carried forward is what was there. It is a continuation of the original meeting.
Okay, very well. Anything else to say?
And my lord, my humble submission is, my lord,
Mhm.
lordship will examine the matters. It's a pure question of law, my lord. And
Not much to deliberate upon. This the interpretation which you are trying to put forth defeats the purpose of democratic setup. Hold on. Let him take stock of his options.
no, my lord, what my learned friend is saying, my lord.
Mr. Chaudhary, one of these days, let Mr. Patwari argue.
Yes, why not? Go.
My lord, may I just, with your
Yes, please carry on.
Yes. My lord, as your lordship has rightly held that under section 34, subsection 2, there is no meeting. But the judgment of this honorable division bench has said, because if there is no meeting, then the vice of section 39 and section 41, my lord, attracts. Now, the honorable division bench has already held that even if there is no quorum at the initiation, it will be a meeting, and the vice of section 39 and
That was a position in the rules. Now, in the act, there is a specific direction that for meeting 10% quorum is required invariably. So if there is not 10%, there is no meeting. in the eyes of law.
No.
That is what the
That
interpretation
is
is.
what, my lord, I humbly beg to differ, my lord.
Definitely that's why we have invited you.
Because, my lord, the honorable division bench has categorically held, there are two decisions, in fact, that if at the initiation there is no quorum, but still it will be a meeting, and the vice of section 39 and 41 will not apply.
Okay, very well, we'll consider then. We'll consider.
Deeply obliged.
Do you need any in the event because
No, my lord, I mean, just my lord, that rule may be seen, my lord, just indicating it, my
the
lord.
rules
Page 46.
which were interpreted in the
Yes.
My lord, if I intervene, the division bench judgment is in relation of the act which has been repealed, 1949 Act. And my lord, we have to understand, my lord, quorum in terms of the present. act, my lord.
Page 46, my lord, and 47. Ditto, my lord, same, my lord,
Yes.
perimeter, yeah. It was in the rules
46.
46. Please come to my lord, rule 3, sub-rule 3. If within half an hour from the time fixed for meeting of the General Assembly, a quorum is not present, the meeting shall stand adjourned and ordinarily on the same date in the next week at the same time and place. But the chairman of the meeting may, however, decide to adjourn the meeting to a date not later than 14 days, as may be provided in the bylaw of the society. Same provision, my lord. Proviso is ad verbatim same. Then 4. If at any time during the meeting of the General Assembly, attendance of members falls below the quorum as prescribed above, the chairman of the meeting, on his attention being drawn to the fact or on his own initiative, may adjourn the meeting to such a date, time and place as he may think convenient. And the business to be transacted at the meeting shall be disposed of in usual manner and at the adjourned meeting even without a quorum. Same language, my lord. So it was in that context that interpretation was given. So therefore, my lord, in my humble submission, under all the situation, it continues to be meeting. And my lord, it is an adjourned meeting. To say, my lord, that under subsection 34(2), there is no meeting, I would respect, my lord, that may not be correct.
We'll consider. Arguments or judgment reserved.
Obliged.
Item number 21.
May I please, your lordship, my lord, here in this case, my lord, petitioner have challenged this impugned sale notice, my lord, dated 21/8/2023, my lord, at page 97, my lord.
Yes.
In fact, my lord, here in this case, my lord, two petitions have been pending before the learned District Court Tribunal. One filed by me under section 17 SA, my lord, and another filed by the bank, my lord, OIA, my lord, for recovery of the amount of rupees 1 crore 10 lakhs, my lord.
Yes.
Here in this case, my lord, they have issued during pendency of this, both the petitions, my lord, they have issued this impugned sale notice with the reserve price of 54 lakhs, whereas as per their valuation, my lord, my property is rupees 1.50 crore, my lord. So it's a totally, my lord, below.
Point it out to the DRT.
My lord,
Point it out to the DRT.
My lord, I have already filed the rejoinder stating all this, my lord. And matter is again fixed on, my lord, in the month of October, my lord, 10th of October. But in the meantime, my lord, if my property is sold out, my lord, I have not.
Mr. Ganguly, how do you explain this?
Look,
Why the reserve price at 54 when your dues are 1 crore 10 lakhs and you have
this matter, my lord, this.
And another thing, my lord, just property is also, my lord, I have a property of 3 khatas, my lord, but in their impugned sale notice, my lord, your lordship may found it page 98, my lord, that is 2 kata 8 chotak, my lord. And I have a 3 kata in there, my lord.
What is the square feet? Building is 2566.
Square feet means, my lord.
No.
That is the
2 kata 8 chatak. All right.
And 8 chotak is I have a 3 katas of land mortgaged with them, my lord. But remaining 8 katas in another sale date is not there in the sale date, my lord. And that 8 kata constitutes 360 square feet, my lord, which have gone, my lord. And in their page 48,
how do you
legal
explain this?
Look, in this case, I do not have instructions, my lord. This matter pertains to the Silchar circle. What I would say is that, my lord, perhaps in view of the matter that SA is already pending before the DRT.
So they should not have issued the sale notice. Why?
He can always file the application.
That is all right. But apparently your dues are 1 crore 10 lakhs. You are keeping the reserve price 54.
I don't know what happens normally because
You get instructions on Monday, we'll hear you.
No, let it be on
Tuesday. Mr. Ganguly appears for the respondent bank. He prays for short opportunity to complete his instructions. list on Tuesday.
Obliged, my lord.
It's a cause list. Cause list. Much.
Cost over meter, item 6.
Yes, what is the IA?
Milord, for condoning the delay, Milord, my learned friend has entered appearance and he has filed an objection, Milord.
How much is the delay?
Milord, the delay is of 333 days, Milord.
How do you
35 days.
explain?
Milord, I have explained, starts from paragraph, Milord. Page, Milord, paragraph 8, 9.
Do you file this application for certified copy after 5 months?
Milord.
For which there is no explanation.
Milord, on from paragraph 5 onwards, Milord, I have it at page 6, Milord.
Yes.
Milord. Some medical issue.
Gallbladder.
Milord.
Gallbladder is a minor surgery.
Milord.
It's a minor surgery.
Milord.
Walk in and walk out.
Milord.
For a gallbladder surgery, you were engaged for 6 months.
No.
Not so as not to get a certified copy.
No, Milord, not only for the gallbladder, Milord, other grounds I have also.
What other? Tell us. He's a teacher.
Milord.
Whether he was attending school during this period or not.
Yes, Milord, after the surgery I am attending.
So the surgery was completed on what date?
Milord, Milord, surgery not of the petitioner, Milord.
Of his wife.
Of his wife.
Yes, when?
On Milord 15/12/2020 and paragraph 8, Milord, I have
15/12/22.
Milord.
So before that, what happened? That is what the period which has to be explained.
Milord.
Pain abdomen. Pain abdomen is nothing. Surgery was conducted on 28th April. Discharge was on 8th May. That's all. Thereafter, nothing.
Lord, again, some.
Before judgment, her husband, wife has been released. So there is not.
Thereafter, there is nothing, Mr. Siddhar. Nothing at all.
Even my lord.
Only you get a radiology done on 14th December. In between, there is nothing. So there is no explanation. Palpable.
No.
That we already told him.
Even my lord, during, he has filed another writ claiming separate post in the month of June.
Oh.
No, that is, no, my lord, that is a.
But not has been annexed with the IMA.
Lord, that is a.
So if he could come down for filing a fresh writ petition, why could he file an appeal?
No, my lord, the fresh writ petition is for a, my lord, different cause of action arising.
Question is not a different cause of action. Question is, after 9th May, he was in a position to come down to Guwahati and engage a counsel and get a fresh writ filed. And he could not file an appeal. Where is that writ? Let's see.
My lord, writ number, my lord.
You mentioned it in your application, in your objection.
Yeah, I mentioned.
Let's see. Where is it?
Paragraph, my lord. Paragraph 8. Paragraph 7, 8, my lord, 7, 8. 7 I have given.
There are 7. Right.
8 also. Even
Dismissed.
My lord, delay may be condoned, my lord.
No, sir, it's not at all genuinely explained. It's a misstatement on the face of it.
I'm over.
Will it?
Obliged, my lord.
Pass over method 13.
May I beg your lordship?
Yes.
Lordship, the judgment is passed by the Honorable Single Judge Lordship. By judgment and order dated 22/12.
Similar appeals we have already heard and we have reserved judgment.
Yes,
So we
Lordship,
should do the same thing here.
but Lordship, if Lordship permits, I would like to submit few lines on behalf of the client.
All right, do that. Good. At least she's making an effort. Yes.
On the previous occasion, Lordship, when the other connected matters were being heard, Lordship was correct in observing that as per Clause 3 of Assam Public Distributions Order 1982, Lordship, the licensing authority may issue licenses to the appointed dealers as may be considered necessary from time to time. As such, there is no doubt that the government licensing authority may refuse to renew the licenses whenever found not necessary. The policy decision was taken to not renew the licenses shops having less than 50 ration card holders. The object of the policy decision is projected to be reduction of the expenses of the state government for distribution of food grains. It may appear that the more number of shops, the more number of expenses, Lordship. However, the situation is not the same. The fair price shops gets commission on the food grains that they distribute, Lordship. For example, if I have a shop and if I distribute 100 kg of rice to one person, I will get the commission like rupees 10 from the government, Lordship. Similarly, on the other hand, if another person, if another distributor distributes rice that 100 kg to that person, the state government will pay that rupees 10 to that person also. So, Lordship, there is no loss on the hand of state government, Lordship.
Okay, we'll take note of the submission. Arguments heard, judgment is out. And there is one in the main list of this hearing list also. Okay,
Item 2.
so that is also same. What's your good name?
R. Shah, Lordship.
R. Shah. Okay. Item number 2 also judgment.
My judgments.